Pacific Cascade Legal, and I'm with our founding attorney, Louis Landerholm, to talk about how to know when it's the right time to make a will. Hey, Louis, how you doing today?
Doing great. How are you, Steve?
I'm doing well. And this is sort of a trick question because I think it's really always the right time to start a will. But you hear people talk a lot about, have you had a will? No, I don't have a will. I don't have enough money. I don't have enough property. I don't really just have enough stuff to make a will. Or they say, well, I'm 22 years old and I'm just too young to even worry about making a will. But so let's kind of talk about those things because they're really not right. And let's maybe start with the I don't have enough to make a will. That's not necessarily the only reason you want to make a will. So kind of can you kind of talk about why that idea is you don't have to own a house to make a will. You don't have to have a giant, investment account to make a will, do you?
No, I mean, I think it's important for everybody to have a will because you never know when a will become important. There's
Yeah.
there's a number of there's a number of things that happen when somebody passes away that then your heirs, your everybody who is trying to figure out, they're in the grieving process, number one, and then they're trying to figure out like what do we do? What's even there? So a will helps to identify what's there. It also helps to identify who should do what and who gets to kind of take control. Otherwise, the state's going to get involved and the state's going to have to direct everything and make decisions and put it in the hands of the courts and all of that. So wills aren't an expensive thing to go get prepared. It's I think it's important for everybody to think about having one and actually putting one together because it basically just cuts out a number of steps in the event of somebody passing away.
Yeah, that's so true. I know of at least three occasions where, someone younger dies and like you said, there's all these things you need to do, no matter if they have a little money or a lot, if they own a car, if they, I mean, just anything, it's going to trigger stuff that has to be done. And it's so much more, I don't want to say relaxing, but it's so much more uh, helpful to at least them have that so that you don't have three different people trying to figure out what to do and how to handle this estate or just even the affairs of the person. Um, but it's not even just about the property, it seems to me. I mean, when you make a will, part of it isn't part of it actually designating the people you want to have making decisions once you're gone. There's all these decisions you may have to have made, even if you don't have a lot of money. And someone has to make them, and you get to make them, not someone else.
Yeah, and it's all about the intent of the person making the will, right? Once once we're not here, nobody can ask us what did you want to have happen? Who did you want to have um, make a decision about? Yeah, the car. Like how does that get taken care of? Wills are meant to avoid conflict and avoid people your heirs who and if you don't have a will, then you go, it's called intestate succession, where essentially it's just you're either going, if you're younger, you're maybe going up to parents or across the siblings or whatever it is, or if you have children and you have heirs, then going down. But what happens, and it can get complicated based off of, how the family's set up. And with a will, you hope to avoid conflict between the heirs. As opposed to an intestate situation where you don't have a will, then maybe somebody can bring a challenge, and that challenge then creates a lot of time and money for all of the heirs, where you can clean that up, make things easier, for the people who are left, and you can appoint a personal representative to do the work for the estate and all of these things. And it's meant to make things more streamlined and make it so we avoid the fights between the heirs.
Yeah. I probably see as much of probate, litigation that we kind of see go through is because one person is saying, well, you know, that daughter is took this and it was actually meant for me. I talked to her before she died and all of this stuff, and but it's not written down anywhere, and it just creates pandemonium
Yeah.
and more litigation. And it also kind of then seems like, okay, we can say, you don't have enough, but even at that, there are, I guess, some like things that happen that you really then start to need thinking about making will. And one of it, to me, feels like once you have kids, because that brings a whole new realm of sort of questions to what's going to happen if you die.
Oh yeah, absolutely. And I mean, for everybody who are parents, I ultimately the state places the kids with who they will place the kids with. But as a parent, you can give your intent and you can help guide that placement with your will so that there's less conflict, try to avoid custody cases that are going on in the probate. And for all of you who don't know what probate is the actual case where the court has to approve the how assets, how where kids are going to go, how we're going to do all of that. It's administering the estate, either through a will or a trust, or well, and trust can help to avoid probate, but that's a different conversation. But um, wills basically give the judge your intent when you were alive, so that you hope that then that flows through the probate process, so that your kids aren't in limbo and you don't have multiple family members coming together to fight over who they should live with and all of the above. So it gets pretty complicated. It's not 100% perfect, because like if say you were divorced and one parent says I want them to go to my like grandparents, but the other parent's still alive. The law is going to handle that differently and generally go to the parent who's still alive. So you can't. It's not 100% where you can direct where the kids go, but it's very important to at least designate your intent and what your wishes are, so that everybody knows that afterwards, and it is not confusion and people basically trying to figure all this stuff out, because there's a lot.
Right. It, and that kind of leads to I've heard this from people like, well, I want to make will. I'm almost ready to make will, but I just haven't. I don't. I need to decide exactly what I want my stuff how to be handled. But if I'm right, can't you change will? I mean, it seems like getting something down as soon as possible, it can be changed, can it?
Yeah, wills always change. Different life changes happen, marriage, a divorce, new kids. Um, Wills can also be drafted. Say you have your first child and you want to draft it, and you can say, that child's name and all subsequent children. So it can look into the future as far as, what, what is happening, whether it's going to happen or not. And so there's some things that can be done where a will can, last longer. But when there's big changes, you can just modify your will, and it's not very complicated. It's pretty easy, actually. People do it all the time. You hear about all of the movies or whatever where people are changing their will on their deathbed and all of this. And yes, that can happen. I think it's less common than what people think. It's more common where somebody comes forward with a written document like, that doesn't follow the will, the will statute. Basically, oh, I had this piece of, I have this napkin that they left me this. Well, that's why we have wills, because then they can go back to the will and say, no, it was meant to be done this way, and it doesn't cause chaos, essentially.
And that just made me think of the word it ensures. You can do the napkin, you can do these things, you can, leave a cassette of what you want to do, but in the end, there is an actual legal way to do that. And unless you do that legal way, you're not really ensuring anything that's going to happen the way you want it. So the process of making a will, well, it has to be legal. It has to be legal. I mean, it's not that complex, is it?
No, it's very easy. I mean, essentially, the main part of it is just the witnessing part, so that way you have the independent witnesses. Outside of that, it's very easy. It's just, basically putting in exactly what your intent, what your wishes are, and then you have the witnesses who can attest to the signature, and that's about it. It's pretty straightforward. Obviously, the more complex the estate, the more complex the will is. But outside of that, the actual process is very straightforward.
And just before we go, we're just about running out of time. If someone, you say, okay, I'm going to make a will. I don't. Is there anything else I should consider? What else? Do I need anything at the time I make a will? And the only thing that kind of comes to mind, to me at least, the main thing is, you can also sort of protect yourself, things like powers of attorney, maybe, or things like that. So you can package something together that's not super expensive, but it can kind of protect you from the time you make it on.
Yeah, there's also advanced directives. So kind of the three that normally kind of go together are a will, power of attorney, advanced directive. The advanced directive tells people what you want to do medically in the event that you're incapacitated and can't tell your wishes. Again, it's all about what is your intent when you are incapacitated or when you are dead, where you can't verbalize your intent. And so that's the point of all of these things. Power of attorneys also give control and power to somebody else to run effects or to be able to access a bank account or be able to make a decision, financially or in a different realm. And so all of those can be sort of thought through and figured out so that people aren't left guessing and trying to operate on their, with their own wishes, and not yours.
Final question. The person who comes and says, well, I have these things, but I don't know what I should say about it, or I don't know if I can give it here, or I don't know how to make this happen. I don't know how to actually write the words down, or what should I think about? We can help them, can't we? With a consultation just even before they write a will.
Yeah, I mean, that's the point of the process. The will process goes through that, to think through what do you have, how do you want to divide it, where do you want, what do you want to include, what don't you want to include, who's getting what. So all of that is part of the process of organizing the estate, organizing your thoughts so that you can get drafted so that everybody understands what you intended.
I love that. I love that. So thank you, Will. Again, Will, you don't look like Will. Thank you, Louis, for sitting down and talking to us today about, how to know when it's time to make a will. And that's why I said will. And thank you, everyone else today, for joining us. If anyone has any further questions, please feel free to contact us, get connected with us. And until next time, stay safe